And now to our second major story. Kenya's Supreme Court has blamed the country's Electoral Commission and its chairman for declaring Uhuru Kenyatta the winner before all the results had been verified. In a lengthy explanation given on Wednesday of its decision to annul August presidential election, the court said the commission's refusal to allow access to its computer servers led them to believe the data could have been interfered with. Kenya's Electoral Commission and its chairman were singled out for declaring Uhuru Kenyatta president when the votes had not been verified and for failing to properly collect results from a quarter of the polling stations. Deputy Chief Justice Philomena Mbulu said the election was neither transparent nor verifiable. Africanews Ignatius Ano and William Bahia have been following the story and now report.
The Supreme Court of Kenya on Wednesday blamed the Electoral Commission for its mismanagement of the presidential election invalidated on 8th August. It also accused the Commission of having proclaimed the results on the basis of sometimes doubtful documents and not allowing access to its computer servers.
It was inter alia neither transparent nor verifiable. On that ground alone, and on the basis of the interpretation we have given to Section 83 of the Elections Act, we have no choice but to nullify it.
The conclusions of the judges, which on Wednesday clarified their decision on September 1 to invalidate the re-election of outgoing President Uhuru Kenyatta, a first in Africa, reinforced doubts about the ability of the IEBC to organize in a short time the new ballot scheduled for October the 17th.
The electoral system in Kenya today was designed to be simple and verifiable. Between the 8th of August 2017 and the 11th of August 2017, it cannot be said to have been so. Our judgment is also simple and, in our view, clear and understandable. It ought to lead IEBC to a soul searching and to go back to the drawing board.
Kenya's constitution requires that a new ballot be held within 60 days of the Supreme Court's decision by October 31st.
Tensions heightened on Tuesday, September 19th, at the entrance of Kenya's Supreme Court. The Chief Justice, David Maraga, responded to repeated attacks on the judicial system. We call the Kenyans in good faith to defend the independence of the judiciary. On our side, we are ready to pay the ultimate price to protect the Constitution and the rule of law, he stated on Tuesday. The Supreme Court has been under multiple threats on social media and political networks, first by President Uhuru Kenyatta, who was announced winner before the vote was annulled, and supporters of the Jubilee Party.
And now we're being joined by Herman Manyora, a political analyst from Kenya. Very good morning to you, Mr. Manyora. And what can you deduce from the report by the Supreme Court judges on the presidential election petition?
Generally, they just confirmed what people had known they would do. There were no major surprises, especially coming from the majority judges. While they found that there were irregularities and illegality, while they also castigated the IEBC, it fell short of presenting criminal liability, either IEBC or specific officers. I think this is what has surprised many people. They absolved the third respondent who was the president-elect, the IEBC, the body running the election, and the second respondent with the chief returning officer, that is the chairman of IEBC. All those and any other officer, they said they couldn't find the full footprints and then actually led them to an individual. That begs the question. Then where is the way in which they were dismissing this election? But basically, that's what I saw.
It is of note that two of the Supreme Court judges were against the majority ruling. What was their basis for going against the majority ruling?
Although they gave different judgments, there are different judgments or reasons for their dissent. But running through the two both dissenting opinion, you discern perhaps two important things. One is that the will of the people as expressed in the ballot must be respected. To the extent that they did not scrutinize the ballot, there was no problem with the ballot. Then they felt the election ought to have been held. Secondly, while they agreed that there might have been illegalities and irregularities, they are stuck with the opinion of 2013 that was based on the elections law, section 83, which says that if there are irregularities or illegalities, those irregularities or illegalities must produce the numbers. Now, to the extent that this petition was not about numbers, they never disputed the numbers, then they were arguing that there was no reason why the majority overturned an election, thereby overturning the will of the people.
Mr. Mayora, recent demands by the opposition and the threat to boycott the elections means elections might be delayed. What is the constitutional provision in case elections are not held within 60 days?
The earliest this election could take place is on the very last day of the 60 days, which is about 31st of October. Now, we are questioned as what would happen in terms of the provisions of the law or the Constitution. There is nothing. The Constitution envisages a situation where elections will be held within the 60 days. And it is silent on what happens should the elections not be held. Of course, Bank of Day will say that means Uhuru ceases to be president. He's already occupying what they call temporal presidency. And according to Electoral, even that temporal president of his will then cease on the first day of the 60 days. That perhaps then will take you to the Supreme Court for interpretation. And the only vague provision might vaguely perhaps be used is the one that says if the president is unable to discharge his duties, the deputy takes over. In the event the deputy is not available or cannot or is not willing to, then the speaker acts for 3 months, which is 90 days, in which another election is held. That is something that will be subject to interpretation by the court.
Having seen recent demonstrations by the supporters of Jubilee, should we be worried about Kenya?
Not at all, not at all. Until that point you are talking about, after 60 days, if there are no elections after 60 days, then we begin to worry, and worry very much. And I think that things is okay. And that explains why this judgment is the way it is. My reading of this judgment is the Supreme Court had wanted a rematch. So that if you say you had won and your victory was wrong, you have an opportunity to win. If you said you had won, you had an opportunity to win. And that's why they were very careful about criminality and the apportioning blame. From the word ago, they didn't want to apportion blame to the party responding to the president, leave him clean. And today they come